So these are the 4 questions I'd like you to discuss. I want you also to assign someone to write down your answers to these questions. And then after about 10 minutes, I will have someone from the group present the answers to those questions. Even the shy group, someone will have to present those answers. And then they will serve as the basis of some future discussion. Okay, so please go ahead and begin discussion. Various specific ethical problems or questions about human rights. I think it's important to do what you all have just done now, and that is to do some strictly philosophical, traditional philosophical work, which is conceptual analysis, and get clear about the concept of a human right. Once we do that, I think that will help us. It won't answer all the questions that we have about human rights, but it will help us make some progress. And I think we can begin to do that by taking a look at the general conceptual framework for any right, not just a human right, but any right. And that the general framework is this. A statement of a right has 5 places, 5 variables. And I'll explain what I mean by that in just a minute. But generally, all rights can be understood by reference to this formula. A person P has a right. I'm just calling P is a placeholder or a variable for any person. Okay, a person or anyone who can have a right. So this could include a corporation, for instance, if you believe that corporations or governments have a right. This refers to the right holder, has a right to something, some object. Okay, I'll just call that O. A person has a right to some object, O, against A. A is the addressee, the person or the corporation, the state or the individual, against whom one has a right. This is the addressee. And the last is...
What about the pursuit of happiness? Is there any addressee?
I'll answer that question in a sec, Farhad. And the last part of the formula is by virtue of G. There is some ground, some basis, what I called before, that which underlies the right, that which explains why the person has the right he does, or she does. And G is the ground, or the basis, the underlying feature that explains why we have the right that we do, or the rights that we do. So I think what we can do is we can analyze human rights by reference to this formula. So P here will be human beings, right? We're going to have to talk a lot more actually about what a human being is for purposes of human rights. It's not obvious actually who is included in the class of right holders, okay, of human rights. Then we need to understand what a right is. So these are the points of analysis. We need to understand what we have rights to, and we will be focused on what we have human rights to. Do we have a right to freedom of religious expression? Do we have a right to freedom of movement? Do we have a right not to be tortured? Are these human rights? Those are the sorts of questions we ask about the O, the object of a right. What do we have a right to? And then you have already provided answers to this question. Who is it that we have rights against? Who owes us duties by virtue of the human rights that we possess? And the answers were quite similar. There was one exception that was compatible. This third group gave the point about corporations and national entities that others had not mentioned. But a common set of addressees were individuals, institutions, and governments. Everyone agreed to that, and then the question was whether or not we should make these two additions that this group identified. And then the last point of analysis is this: what explains why we have human rights? What feature of human beings, or features of human beings, is what underlies, or as philosophers sometimes put it, what, in English at least, what grounds the right. So let's take a look at this, let's break this analysis down piece by piece and see where we get to. Are there any questions about what I've said so far? Am I speaking too fast? No. Okay. All right. Let's talk first about the nature of a right. Okay? I want to do a little bit of conceptual analysis here, and I want to borrow, this is not original with me, I want to borrow a framework that has that was developed almost 100 years ago by someone at Yale University, Wesley Hofeld. Has anyone heard of Wesley Hofeld? Mm-hmm. Some have not. Okay. Wesley Hofeld. Also, I know I have terrible handwriting. If you can't read what I've written, just tell me, okay? Wesley Hofeld wrote a book called Fundamental Legal Concepts in 1919. In that book, what he did was he said the term right has the term right has in fact 4 different meanings, and it's very important to distinguish these 4 different meanings. The first kind of right is what he called a claim right, and this is the sort of right that we talk most about in human rights. A claim right is a demand for what one is due. It's a justified demand or an entitlement to something. And when you have a claim against someone, that person owes you a duty. So here's a simple example. Let's suppose I do have this watch, and you say, Russ, that's a beautiful watch, I'll give you $20 for it. And I say, okay, that's fine. I wouldn't actually say that, but let's, because it was a gift from my wife, but I give you the watch, and now, after I've given you the watch, and we have made this promise, I now have a right to what? To your $20. I have an entitlement. I have a justified demand against you, and that leads you to have a duty to me. Specifically, a duty to give me the $20. Right? That sort of right is what Hofeld called a claim right. And that is the most familiar kind of right. We can call it an entitlement. And an entitlement is correlated with someone else's duty. If I have a claim right or an entitlement to your $20 against you by virtue of a promise that we have just made. Okay? And that means that you have a duty to me, to, in this case, to give me the money. But that's only one, that's the most familiar kind of right, but it's only one. Farhad, you may not object, but you may ask, I'm just kidding, of course.
The right for claim for the money is arise not from the right of the property, but from transaction of selling. You sell, you have transaction, okay?
That's right.
It's not directly arise from the right of the property to write the claim for the money.
Oh no, well maybe I misspoke. What I meant was you're challenging me on this, right?
Actually, I challenge it. It's an element of the right. You know, I think we don't have such an element as a ground of the rights.
I see. Oh.
Actually, we have it. Rationally, we have it. Of course, every right has its own rationale. It has own ground.
Yes.
But when you see at the structure of the right, you know, we can't see the rationale of the right. Why we have this right?
Oh, okay, that's a very interesting, I think that's a very interesting challenge.
You can use it during the interpretation of the law.
Uh-huh.
I mean, if you have a legal problem in the court, in the trial, you can interpret the law and say that why I have this right, why the legislation, for instance, try to protect my interests here. I mean, sometimes you can refer to the ground of the right.
Okay.
But directly, it's not an element of it.
All right. I can accept that. So what I'd like to do is I would like to be open about this. Some people prefer to understand the ground of the right as an element of the right. But if, like Farhad, you think, no, this is a separate, this is not part of the right, this is just part of the explanation, or as you put it, the rationale of the right, but not an element of the right itself, that's perfectly fine. What we will need to do is answer this question about human rights, whether we regard this the grounding question as answering what is an element of the right or what is separately the grounding of the rights. What I want to do is just draw our attention to the fact that we need to answer this question. Okay. Yes, and you will have to tell me your name when you ask me questions. I can't read that.
It's Arabic, it's not asking the question.
Taras, okay.
But without G, there won't be a right. It would be a moral demand. It's to Farhad. So G is the thing which makes a right a right.
Okay, I think you two can agree with one another. So what Farhad, I know you don't believe that, but let me see if I can make peace here. I think what you could say is, what Farhad could say is, no, Taras, that's not, in this case, let's just stick with my example of making the promise, say, to you. Now I have a right to your $20, since you have my watch, let's say. In that case, what Farhad could say is, Russ, tell me what this right is. The right is only that Taras give me $20. It's not that Taras give me $20 because he promised $20 in exchange for my watch. And I think that in the end, this is not really, there is not a lot philosophically that depends on how we resolve this question of whether the ground is a part of the right. What we will need to do is agree, at least with Taras, at least this far, namely that for any right there must be a ground. Without a ground, there is no right. Without an explanation, there is nothing to be explained.
Normative explanation, normative ground, or
yes.
Factual ground.
It has to be. There has to be a normative ground without.
And factual.
Well, if there is a normative ground, then there is also a factual ground, because there is a factual ground for every normative claim. I will defend that claim on day 3. So it's okay if you disagree with me, but we can't take time right now to discuss that. Let's leave that open.
If I may ask one more
Yes,
question.
of course. You're Sergey, yes?
Slavic.
Slavic, I'm sorry, Slavic.
No problem.
I'm sorry, Sergey. Sergey. I know, you're Sergey too. Okay.
So if
Sorry,
you
Slavic.
talk about claim, it may be money or your life also. And I'm asking, perhaps this Wesley Holfeld, he was reading German theorists of law, and I think at that time they already defined the term which is used also, which is Rechtsanspruch. Maybe you understand that they differentiated from Recht and Rechtsanspruch. That is something that is not guaranteed, but a person believes he has a right, a claim to it. It should be guaranteed because of various reasons. Is this Rechtsanspruch the same as claim, which is defined by Wesley Holfeld, or that's a different thing?
I actually don't know enough about the German tradition to answer that question informatively. So I'm going to confess my ignorance.
But this is not the claim, any claim in the world.
It's not any. So we can make many unwarranted, unjustified claims. For instance, I can say, Slavic, you know what? I don't have a lot of money right now. I don't know if you do, but I don't care. I claim $1,000 from you because I need it. But that's not. I could make that claim, but that's not the sort of claim that Hofeld is talking about, because my claim would be an unjustified claim. If you have a genuine claim rights, then by definition, it's a justified entitlement.
So I guess that means rechtsanspruch.
Okay.
In German, or in the same in Ukraine.
Okay.
Which
It's
is differentiated from a regular right, which
well,
is usually guaranteed on a paper, on a book.
oh, okay, I see. Okay, we will, okay, I'm going to get to that distinction in just a little bit. What I want to do right now is talk about the three additional kinds of rights that Hofeld identified, because at least two others are also forms of human, or I should say this, familiar forms of human rights are also instances of at least two other kinds of rights that Hofeld identified. One,
Для наших ребят это претензия, да, не право, это не обязательно претензия, это не право, но это claim, то, что мы говорим. Наверное, надо отличать. I just said that in our language. We call it претензия.
okay.
Claim.
Okay.
That doesn't necessarily mean that you have a right. Claim is not necessarily right.
Okay, so I want to, because a claim is a kind of paradigm of a right, at least as Hofeld understands it, I want to make sure that you don't get this right just by the act of claiming something. Because as I gave the example, I can claim $1,000 from you. That doesn't automatically give me the right, of course. Okay. The second kind of right that Hofeld identified was what he called a liberty. We sometimes call this freedom in English. And these two terms are used interchangeably as technical terms. And what it strictly means is the absence of a duty to refrain from something. The absence of a duty to refrain from something.
What is refrain?
Refrain means not to do it. Thank you, Sergey. So let's say, as we came into the room this morning, everyone had a certain kind of right, a liberty right. And that liberty right was to sit where you like. If you decided that, what's your name?
Natalia.
Natalia. If Natalia decided that was her chair, she walked in and she said, that chair is mine. I claim it, I'm entitled to it. Natalia wouldn't do that because she's in the shy group, I know that. And you're a nice person, I know that. But if Natalia did that, she would be wrong. She was not entitled to that chair. But she might say, since she was the first one to sit down in it, I have a right to it in this sense. I am at liberty. I have a freedom to choose that chair. I am not entitled to that chair, but I have a liberty in the sense that there is no duty that tells me not to sit in that chair. I am free to sit in that chair. And that's another sense of right, and that in fact is a very important kind of human right. So if you think, for instance, of freedom of expression, to say what you want, one element of that right, and many think of that as a classic human right, is liberty. I have no duty not to speak my mind. I know that's a little confusing, two negatives, but the absence of a duty not to speak my mind, an absence of a duty to refrain from speaking. Fahad.
I have a question. I actually don't have an exact answer for this, and I want to make it clear. I think that the claim is not a ground for right in any situation. It's maybe this is procedure to have, to implement right. But maybe it could be any circumstances where the claim solely is the ground of the right, but I don't think so.
We're not talking about grounds.
Maybe
No, we're
claim
talking-
is not the first.
I'm not
It's not the
sure.
first place. The
I'm
first
just-
place is liberty, and then maybe claim.
This is theoretical answer, actually, what I want to find.
So I want to distinguish between two things. One is the ground of the right, and one is what the right is in essence. And this distinction I'm making is not about the ground, but rather what the nature of the right is. So when we think about rights, we often think about what we are entitled to. And when we think in that way about rights, then we are thinking in Hofeld's terms about claims. If you prefer, you can think about entitlements, but surely some rights of ours represent entitlements. And those we talk about as claims. But if you prefer to talk about them in terms of entitlements, you may. That's perfectly fine. There's a third class of rights, and this class is important, but not so much, I think, for human rights. Maybe you'll convince me that I'm mistaken. This third class is called powers. And power rights are those rights that give us the power to change someone's status. Someone's status. What's status? Status. Okay. So if you think about, for instance, a legal right, a judge has many power rights. A judge can change me from a single person to a married person, right? That's one of the, in America, what a judge says at the end of a wedding ceremony is, by the rights invested in me by the state. And what he means is, or what she means, what the judge means is that the judge has a certain ability to change people's legal status. Now we also have moral power rights. So we each have, for instance, a power right to change our claims, at least our claims, for instance, through promising. I have the right to change your status, anyone here, as the owner of this watch. I have that status, but I can give you the watch or I can sell you the watch. And what that means is I have a certain kind of moral power. It's not a very important power, but it's a kind of moral power, and what it amounts to is an ability to change the status of myself and other people as well. To me, this kind of right, it's important to discuss because, just for purposes of making sure we understand the full distinction, the set of distinctions, but I don't think that human rights, many human rights, are instances of powers. The last kind of right is very important.
No. 1 minute, please.
Okay, I'll just write this and then I'll take the question. Where's the question? Tell me your name, please.
Alexander.
Alexander.
The difference between claim and powers is not clear for us.
Okay.
What different?
Okay. So it may some things, for instance, you are entitled to, not because many people think, for instance, that we are entitled to certain respect. Not because anyone gave us that respect, and that entitlement does not amount to a power. That entitlement does not amount to our ability to change the status of anyone. It's just...
So, can we say that realization of claim is not dependent from us? The realization of power depends from us.
The realization of a power definitely depends on us because it is the ability to change our status. Some claims do depend on us. Whether you have a claim, for instance, to this watch depends on what I do and depends on what you do. But some claims depend. This is now getting into a controversial area, but according to some people, we have some claims naturally. We have certain natural rights that do not depend on what anyone does. We are just given them by birth. That's a controversial claim, but that would be an example in which they don't depend on any action of ours. The last class of rights is immunity rights. And what immunity rights are is they are the absence of someone else's power over you. The absence of someone else's power over you.
What's the difference from What's the difference
Okay,
from
I'll explain it. I'll explain it in just a second. So if I have an immunity right, for instance, when one part of my right to say what I want is an immunity right. What that means is that no one and no government has the power, moral power, to silence me. They don't have the power to change my status into someone who no longer may speak. So an immunity is when someone else lacks the power over you to change your status in some way. So what a liberty is it's the absence of a duty to refrain from something. A liberty just means that I have no duty to refrain from speaking or from sitting in a certain chair if I want. And immunity means that everyone else lacks the power over me to prevent me, for instance, from doing what I want in a certain sphere, in a certain area.
In a situation when we link together the right and the duty, it could be the same.
That's right. So Sergei has said something very important. Many of the classic human rights are linked, have more than one of these elements. And in fact, one way of understanding the theories of different rights, different philosophers of rights, is they have different views about which of these four elements figure in different, they call them packages of rights or groups of rights. So I've already mentioned the right to freedom of expression or freedom of speech. It might be that freedom of speech includes more than one of these elements. It would be a mistake to think that for any right, it must be only of this kind or this kind or this kind or this kind. A right can be a combination of these different elements here. So let me just give an example by way of freedom of speech. Suppose that someone paid me some money to go give a talk at a university. And they said, you are going to be giving that talk in room 100. In that case, we make a deal. I say, yes, fine. In that case, I could say, I'm entitled to speak in this room. I'm also at liberty to speak here. And furthermore, if people start yelling at me and saying, I don't like what you're saying, boo, and stuff, I can say, no, I have an immunity from your interference. Now, of course, I'm speaking about a moral right, and moral rights are not always honored. So I could say, well, I have an immunity. That means that you do not have the power, you people who are yelling at me, shouting at me to stop, you do not have the moral power. Of course, you have the vocal power, but you don't have the moral power to silence me. So my freedom of speech is actually, I think, a group or a package of three distinct kinds of rights. Now, I think we need to keep that in mind when we go and talk about which human rights we actually have. But in order to understand that, I think we needed to understand this distinction here. Sergei has told me that at 11:20 we are to take a coffee break. It is 11:20. So you are to take a coffee break right now. Arise. That's over someone else. A claim is always connected with someone else's duty, either for someone else to do something or for someone else to not do something. So a familiar human right is a right to life, for instance. A right to life is often understood as a claim, a justified entitlement to remain alive, and and that includes everyone else's not doing something, namely not killing me, right? So a claim does always involve other people's duties. Sometimes a claim involves only one person's duty. For instance, if Stanislav and I give you my watch and say, I'll give you my watch, but only if you give me $20. Once I give you my watch, I now have a claim, not on anyone else, but just on you, that you give me $20. A human right is a different kind of claim. Human rights that are claim rights are different in this respect because they are addressed to everyone, not just one single individual. The power, however, is different from a claim in this respect, in two respects. One is that, unlike claims, powers are not always or even usually connected with the duties of other people. Rather, powers are connected with one's own authority to change the status of an individual. Now, as I understood your question, part of it was, are powers different from claims because powers deal only with oneself, and whereas claims deal with other people? The answer to that question is that powers don't deal only with oneself, they can also deal with other people. It depends on which kinds of powers you have. Some powers are powers only over oneself, to change one's own status. But the more usual case is a case in which you have a power to change someone else's status as well. For instance, in the example I gave, a judge has a legal right to marry people who are as yet unmarried. And that is a kind of power that the judge has, a power right to change the status of other people, not himself in that case.
But they have duties.
Excuse me?
But they have duties, these people. So
Judges?
No, not judges,
but
the people who are
the
married.
people who are getting married.
Yes. As for me, every time somebody changed my status, I have the duty to execute somebody's decision on changing my status.
You have a duty to execute that decision?
Yes, yes. And every time, because somebody is powerful, so I have a duty to execute anything he does.
That's right. So the fact that there can be powers that are not exercised or realized. For example, a judge has a power to marry people, but the judge may not decide to marry two people, for instance. So I know you're not married because I asked you yesterday. So, but there are judges in the Ukraine. They have not yet exercised their power to marry you and somebody else, right? So many powers I have moral powers over my children, for instance. A great many moral powers over my children. I don't exercise all of those powers. That is, I could change the status of my child from someone, well, my kids are very old now, but imagine I had younger kids. I could change the status of my child to say, well, although before you had the privilege to stay up until 9 o'clock at night because you have misbehaved, you no longer have that privilege. You no longer, in fact, are at liberty, nor are you entitled to stay up until 9 o'clock at night. That's a very small example. It's not a human right, of course, but that's a right, that's a case in which I, as a parent, have a power, and sometimes I exercise that power to change my child's bedtime, and sometimes I don't.
You change status of your children, you also make duties for your children.
Let's see. That depends on whether every status has a set of associated duties. And I'm not sure about that. There are many, many, many statuses. What I can say is that if a status has some duties associated with it, then when someone else exercises a power to change your status, if that status has duties associated with it, then once your status has been changed, you do assume those duties. But I'm a little reluctant to say that every status, every moral or legal status, has duties associated with it. Many do, of course, but I just don't know whether all of them do.
And why are you reluctant?
Excuse me?
Why are you reluctant?
Well, because, as I say, there are probably a million different moral and legal statuses someone might have, and I haven't thought about all of the different ones, and so I don't know why conceptually it's required for some status that there be duties associated with the status. There might just be, for instance, liberties associated with a certain status, and the absence of duties. I don't see why that's impossible. So if it's possible, then I would say to Dima that although someone else has changed my status, that doesn't necessarily mean that I now have new duties.
Why?
It means I have new rights, but those rights could be liberty rights or power rights. For instance, when a judge, let's say I am a new judge, and some other judge has just performed the ceremony to make me a judge. That judge has a power right over me. He has changed my status. I used to be an attorney, and now I am a judge. Now that my status has changed, I am now a judge. I have a set of new powers that I didn't have. I also, in this case, have a set of duties.
Yeah.
I also have a set of entitlements, and I also have a set of liberties. But I don't know that every status has all four of these different sets of rights associated with it. I would need to see an argument for why that's necessarily so.
In your example, when Jared changed status, for example, of two man and woman, and they become married only after his decision, yeah?
Yes.
So, if my status is changed and I'm now married with somebody else, I have new duties, but not before judge, but before my wife, for example.
That's right. But you have duties by virtue of your new status. The status of a husband has duties associated with it. All I'm saying is that there might be some statuses out there that do not have any duties associated with it.
I have duties in virtue of your powers. My duties are the consequence of your powers.
Yes, that's true. In this particular case, your duties are a result of my powers. That's right. In other cases, duties don't result from powers, but from entitlements, for instance. If I have a right to life, I may have a right to life not because anyone has changed my status in any way. In fact, I might know if I have a right to life, probably no one has the power to take that right away from me. And yet that right to life includes many duties on the part of other people. So an entitlement a claim always brings duties for others. But it's not clear whether the exercise of power always brings duties with it. It often does. I'm just reluctant to say that it always
Ти можеш
does.
розлучитися і втратити ці обов'язки. От і все, ти маєш цю liberty.
Це теж наслідок чиїсь рішення.
Але ти маєш liberty.
Oh, here's an example.
Проясните просто, или что-то, это объяснение прояснило или нет.
Dima, I've just thought of an example. Suppose I'm very rich, and I have a very large property. Now it's my property, so I am entitled to use it as I wish. But I also have a set of powers. And let's say that you come and visit me, and I'm very rich, and say in the first case I don't know you. So in the first case I do not give you the authority to come on my land and to enjoy my land. But in the second case, I say, "Oh, Dima, welcome to my large property. do whatever you would like on my land. There is nothing prevented to you. Do whatever you want. In that case, I have the power to change your status from someone who is not allowed to enjoy my land to a different status. Now you have the status of someone who is allowed to enjoy my land. But there is no duty on you. I tell you, and you say, well, what may I not do? What am I forbidden to do? I said, Dima, you can do anything. No duty at all. Now, I might be foolish to say that, but it makes sense for me to say something like that. In that case, I've exercised a power over you. That's not always a bad thing. That's something that this example shows, is that a power can actually, my having a power over you can be a benefit for you, not necessarily a burden on you. I'm now making you better off because you can enjoy my land than you were before. But in this case, it doesn't seem that you have any duty that stems from the power.
This one is better example.
Okay. Thank you. Other questions?
There was one question raised in the discussion whether there was one criteria.
One criterion of division, but
Is there any
four
one
aspects.
criteria by which you differentiate these four classes of rights?
There is no single criterion by which these different classes are divided. What Hofeld tried to do was he tried to understand the basic categories in which the English term right is used. And what he said was, people use this right to refer to four different kinds of relationships between people. The claim relationship, the liberty, the power, and the immunity relationship. That's just the way that the term is used, but he thought there was no single criterion he used for distinguishing these four classes from each other.
Was it an empirical classification?
It was, in the beginning, of course, it was an empirical, or I would say it was a semantic or conceptual distinction. There was, as he understood, four different meanings of one word. And because these meanings were not distinguished, much talk about rights was not very productive.
Actually, I have by chance his article of 1913, and I see, can find it right now. He mentioned some other, maybe not of his, classifications like 10 types of classes of rights.
That's too many.
Too many. This is all.
And that's his article, right? So in the book, he compressed it. He reduced those to four basic classes.
I see. So 1919, right?
Yes, fundamental.
1913.
Yes. Other questions? Yes, Vladimir.
So we have four kinds of using the word right. Yes, right is claim, right is liberty, right is powers. I just wanted, I wonder if we can give a definition of human rights if we have four different types of usage of this word.
We can give a definition of human rights even though there are these four different kinds of rights, because what we can say is we don't have to say that every human right, for instance, is one of those, is a claim right. What we can say is that human rights, we haven't yet come up with a definition, but here's a beginning definition. A human right is a right had by all human beings in virtue of their humanity against all other human beings. Now, that's just a start. It's not the finished product yet. But what we can say in that definition, it's a right of all human beings against all other human beings by virtue of the humanity. Just a second, Farhad. By virtue of the humanity of the right holder. That can be a definition of human rights. It doesn't yet say which rights are human rights, and it doesn't say whether the rights are claim rights or power or immunity or liberty rights. But I think that's as it should be. I think that's a good thing, because when you define a human right, that's different. Defining the concept of a human right is different from enumerating the rights. What you want is a very general concept that will be shared by every single human right there is. And the general concept I gave, I think, will be shared by every single human right. It's just not clear whether it's enough to distinguish human rights from other kinds of rights. Farhad.
My objection is that the address of human rights is not other human beings, but it's the state usually. And we told about, the transnational corporation, international organization. Why? Because, for instance, if someone else, I mean a physical person, is going to injure me, it could be civil litigation or criminal litigation, but it's not a subject of human rights. If I'm talking about human rights, we should, the address usually is a government. I mean, we sue them in the courts, in the European Court of Human Rights, but not a physical person.
Okay, we're going to talk about who the addressees of the rights are in maybe, well, it depends on how many questions there are, in maybe 25 or 30 minutes. So I'd like to just postpone that question, or that objection. Are there other questions before I move on?
This is also one such a question. Absence of someone else's power above me, as for me, is the same as absence of my duties. Yes or no? Absence of your power above me.
No, it's not the same thing. No.
Absence of my duty.
No, it's not the same thing. So the absence of if I lack a duty, that makes no reference to anyone else. But the absence of someone else's power over me is necessarily a two-person relationship. So an immunity is necessarily at least a two-person relationship. It means someone else, maybe no one else, maybe just one other person, maybe a group, it doesn't matter for right now, but at least one other person lacks a power to change my status. Whereas the absence of a duty, so a liberty, need not refer to anyone else at all. It's just that I lack a duty. So there's that difference. You're welcome. So in that case, I will proceed to make some other. Today is our conceptual day. To me, that's not as much fun as the stuff we're going to do tomorrow and the next day. But we need to get the conceptual stuff taken care of. So what I want right now next is to talk about duties, rights and duties, because many people think that every right has a duty connected to it, and other people think, and some of the same people think, that rights really are nothing other than duties. So I want to talk about these two positions, these two ideas that connect rights and duties. The first idea is that every right has, in English we say, a correlative. What's the Russian? Okay. In every right, here's the thesis. Every right has a correlative duty. I think we can see on Hofeld's analysis that this is not true. Every claim has a correlative duty. But it is not the case, for instance, that every power has a correlative duty. That was Dima's question that I tried to answer earlier, to show that not every power has a correlative duty. And not every liberty has a correlative duty. A liberty, and this I just explained to your last question, Dima, a liberty just talks about the absence of my own duty. It does not talk about anyone else's duty. So it's really, when we naturally think about the link between rights and duties, that is really appropriate only to claims, entitlements. My justified entitlement to something, say my justified entitlement to remain alive, my right to life, does entail, it is correlated with the duty of everyone else to respect my life. But these other kinds of rights are not necessarily related to duties.
What kinds?
The power right, the immunity right may be connected with duties of forbearance. What's the Russian word for forbearance?
Выносить что-то, быть способным.
For refraining from interfering with liberty. Okay, so that was the first thesis. The first thesis is that every right is correlated with a duty. And that is not the case, though every entitlement or claim right is correlated with a duty. Okay. Yeah, Farhad?
What about this formula? If there is a remedy, there is a right. If there is no remedy, there is no right.
It's not clear that that's true. I don't know, are you just thinking about in the legal context?
Yes. Of course.
Okay.
If you can apply, там main qualification. Remedy, если у вас есть право обратиться в суд.
Ну, защита.
Судебная защита, да.
Ну, не обязательно.
Судебная защита.
Не обязательно.
Да, не обязательно.
Юридическая.
Юридическая защита.
That depends. That's actually not, I don't think that we can answer that conceptually, but rather substantively. We need to talk about what the conditions of just remedies are. But I think it's possible for there to be a remedy for a situation in which so let's say I am injured in some way and I seek a remedy. It's possible for me to receive a remedy that I am not entitled to. In that case, I think it's possible to have a remedy without a right.
Or have a right without a remedy.
Oh, that's a different thing. It's certainly possible to have a right without getting a remedy. It may be possible to have, it's a much harder question about whether it's possible to have a right without any possible remedy.
I think it's possible, yeah.
We have to talk about that tomorrow, because that actually raises complicated questions about how rights are connected with what duty bearers are able to do. So I want to defer that question, but I promise you I will talk about that tomorrow. Okay, there was a second question, a second thesis about the nature of rights and their connection to duty.
Excuse me. Again, so this thesis doesn't work only with powers. Is that correct? Is your position? With other claim liberty and immunity?
It does not work with liberty, no. You can be at liberty to do something without anyone else having a duty. So for instance, Natalia, say, was at liberty to sit in that chair, but no one else had a duty not to sit in that chair. Everyone else was at liberty to sit in that chair as well.
But everyone has a duty not to make her to sit there.
What?
They have a duty, what?
They have a duty not to make her to sit there.
They have a duty not to force her
Yes.
to sit there. That's,
Yes, because she has a right to sit there, and
she is at liberty to sit there,
yes,
so...
and I have a duty not to force her.
That's right, but that doesn't follow from her liberty. That follows from her entitlement to a certain kind of freedom of movement. So it's not her, I was thinking about her being at liberty to sit in that chair. That does not impose a duty on anyone else, because anyone else was at liberty as well to sit there. But it might be a separate thing, it might be a separate kind of right that creates the duty against coercion, for instance, against force. It might be an entitlement to autonomy, say. I'm not sure exactly how we would describe that right. Okay, the second thesis is what is sometimes called a reductionist thesis. What's the... Okay, reductionist thesis. Some people want to say, really, rights are nothing more than duties. That's all. I think this is a problem for two reasons. One is that, as we've already seen, some rights are not correlated with duties. So this will not be a good analysis, for instance, of power rights. Power rights cannot be reduced to duties because they're not even correlated with duties. But even with
example,
excuse me.
Could you give an example?
So my power to determine when my children will go to bed is not the same thing as a duty of mine. So my power cannot be reduced to any duties I have.
So you mean the duties and powers of one person?
Yes.
Of the same
Yes.
person.
So
Same person.
yes. So let me get. So many people are thinking in terms of claim rights and entitlements, and what they want to say is that there is no such thing as an independent right that serves as the basis of the duty. We have only duties to other people. So, for instance, my right to life is nothing more than everyone else's duty not to kill me. That is all my right to life is. It's just everyone's duty not to kill me.
That is not true, is it?
And I think that is not true. I think instead that rights are independent in this sense. Claim rights are the grounding of everyone's duties. So, for instance, if I have a claim right to life, that's what explains why everyone has a duty not to kill me. It is not the same thing as the duty, but rather it entails the duty. What's the word for entail? So what we have is not an identity claim. It's not that the right and the duty are the same thing. They are different things. And this is important because if we look at it this way, then this allows us to see that being a right holder is a very important status. Not only do you have a duty to me, but I can control that duty. My being the right holder, my having the right, gives me a status of importance and independence that does not necessarily come just when other people have a duty to me. Let me give you an example. It might be, let's say imagine that this is a beautiful painting. It's not, but imagine this is a beautiful painting. It may be true that I have a duty not to destroy this painting. But suppose this painting belongs to no one, not even the hotel. I know that's not very realistic, but just imagine, it's not realistic to think of this as a painting either, but we're doing philosophy, right? So imagine this is a beautiful painting. I may have a duty not to destroy it. That does not mean that the painting has a right.
Because it's an object.
It's because it's an object, exactly. So what this shows is that even though I have a duty not to harm something, in this case this painting, that does not show that there is a right that's correlated with a duty. And what that shows is that just because I have a duty not to harm, that does not mean the same thing as he or it has a right that explains or grounds or justifies the duty. So there is a difference, I think, between there being a right and our having a duty. In this case, our having a duty not to harm an object, or speaking about a right to life, our having a duty not to harm a human being. Okay. Let me move on now to another distinction. This is something that was raised a bit earlier. And this is especially important in the context of human rights, because oftentimes discussions about rights get confused because we fail to distinguish between moral rights and legal rights and other kinds of institutional rights. Here's the question. Are human rights only legal rights? Or are human rights also moral rights? What we can say is that rights come from within a certain system. There are certainly legal rights, and the legal rights of citizens of the Ukraine are not exactly the same as my legal rights, for instance, as a citizen of the United States. Because we have different legal systems that generate these rights. The question is, are there also moral rights? So is there a system of moral rules that generates moral rights? My view is that the answer is yes, there is. This is not everybody's view, and many people who are quite smart disagree with me about this. Many people think that human rights are essentially legal rights, so that if a body of law, maybe a body of international law or domestic law, but usually international law is the focus. Many people think that if in international law a certain right is not recognized, then it cannot be a human right. And my view is that that is a mistake.
That's actually Joseph Russ's point.
Well, like I said, some very smart people disagree with me. I disagree about this because I think that if we ask, I can't prove this, okay? And so I'm not even going to try, but I am going to give some arguments tomorrow and the day after. They're going to try, that might help my case a little bit. But
when you're ready.
You can, okay, hang on just a second, Farhan. And I'll bring you up here later.
Okay.
You can see, okay. I think that when we ask, let's consider the situation in 1946, before the Universal Declaration was handed down, okay, was ratified. It seems to me that if there are any human rights, and we will talk tomorrow about skepticism about human rights, because many people are very doubtful about whether there are any human rights. But let's just for right now assume that there are some human rights, and one of them, let's assume, is the right not to be tortured.
Okay.
Now, I have not made any argument about that. I'm just asking you to make this assumption with me. What I say is that it's very plausible to think that if there is a human right not to be tortured, then that human right existed in 1946. But you say there was no International Criminal Court, there was no UN declaration, so there could be no human right. And what I want to say is there was a human right, but it was not yet legally recognized. The human right is a moral right. And the reason I say this is for two reasons. One is because it seems to me that the law is never morally perfect. The law is made up by people like you and me, and we are not morally perfect. So the law is a result of compromises. It would be a miracle if the law were morally perfect. If the law is not morally perfect, it should not have the final say on which moral rights we have. Now, if you believe that there are such things as moral rights at all, then I ask you, why can there be no moral rights that are had by all human beings in virtue of their humanity?
Because moral is
Can you
different
say it again,
in different society.
Ah, okay. Because the morality is different in different societies. I'm going to devote the entire third day of my lectures to this kind of objection. This is called, within the human rights literature, the ethnocentrism objection, or sometimes the Eurocentrism objection, or the relativism objection, or the parochialism objection. What's the word for parochialism? The idea is that human rights are universal rights, but there can be no universal rights, there can be no universal moral rights, because there is no universal morality. Yes?
And what about history and historical changes of essence of human rights? Maybe in 1946, yes, rights were moral rights, but after Universal Declarations, all the rights are now legal rights. There are no
Yes.
moral rights.
Well, it's the last thing you said that I object to. I don't know why just because they are now legal rights, they no longer are moral rights.
They are also moral,
Okay.
but they're legal.
Okay, I agree with that. That's perfectly fine. I think that human rights can be both moral and legal. What I want to do is I just want to open up the possibility that before the law recognizes certain legal rights, there might be moral rights as well. And what intelligent lawyers and politicians are doing is they are recognizing that we have a moral right to life. They are recognizing that we have a moral right to physical security, which includes a right not to be tortured, for instance. And when they recognize that, that's why they are, if you ask, why are you making this law? Why are you including a right to physical security in the United Nations Declaration? Why? And I assume the answer that the people would have given in 1948 is, we are including this right to physical security, which includes a right not to be tortured, because people have a moral right to physical security. And we want to make sure that every country in the world recognizes that moral right. If instead, what else would they say? Well, I don't know. We just sort of like that. That wouldn't have had as much force as if they said, we recognize that there's an independent moral right and we want to enshrine, we want to incorporate this independent moral right and make it a legal right as well. Okay. But I know that there's a lot of skepticism about that, and as I say, I can't in 3 days answer all that skepticism, but the objection that you initially gave, which is there's lots and lots of literature now written about this objection, is going to be the focus of our third day together. Okay. Let me talk now a little...
You said moral and other, moral, legal and other.
Oh, institutional rights. So there you can have, by being a member of some kind of institution, it could be, for instance, a corporation, or it could be an institution like the judicial institution in a society. You can get certain judges, for instance, have certain rights by virtue of their role in an institution. I have certain rights by virtue of my role as a professor in a university. And it makes sense to speak about, for instance, professional rights. So that's another context in which we can acknowledge the existence of rights. And those rights, too, come from separate sets of rules. So my university, for instance, has a very long rule book. And one of the things that happens in that rule book is that a whole variety of rights are instituted for professors, also for students and for staff and things like that.
And then you said also that you have two arguments for your thesis. The first one, law is never morally perfect. Mm-hmm. And the second, maybe I missed it.
The second argument for thinking that there are independent moral rights is to ask why lawyers and politicians would create the legal rights that they do. And the natural answer, it doesn't have to be right, but the natural answer is that they are recognizing in law moral rights that already exist. So that's why I asked, for instance, if you were to pose the question to those who ratified the UN Declaration in 1948 and say, why do you think that why should we include a right to physical security in this document? Presumably they would say, because every human being has a moral right.
Maybe dignity.
They might cite dignity as the basis of the right. And we're going to get to that shortly. Here's another distinction I want to make, and this is something that's already come up about the addressees. Who do we have human rights against? There is no consensus in the human rights community, at least within the human rights legal and philosophical community, about this question. And so I'm not going to try to take a stand on this. I just want to make sure that we understand the different options here. Some people think that only governments are the addressees of human rights. We have human rights against governments, not against individuals. Farhad made this point earlier.
I can't prove it.
Okay. Okay. I think that there's no question that we do have these rights against governments, but of course only if these rights are understood as moral rights. Because if they're understood as legal rights and your government has not ratified the UN Declaration, then you have no human rights at all. And that should give us some reason to worry that human rights are only legal rights and not also moral rights. But I think in general that we do hold that the government is the addressee of human rights. But there are other people like James Griffin, who is a very influential English philosopher who just wrote a book on human rights. And if you take a look at Griffin's book, he doesn't mention he mentions governments almost not at all. The book is 350 pages long, and he talks about human rights as being held by all humans against all human beings. Now, governments, of course, are comprised of human beings, so we can say indirectly that according to Griffin, the governments are addressees of human rights as well. But part of resolving this question about who our human rights are held against, to whom are these human rights addressed, part of the difficulty of resolving whether they are addressed to all human beings or to just governments or other institutions, part of the difficulty of resolving that question is explained by, I should say, the difficulty of knowing whether human rights are only legal rights. If human rights are only legal rights, then it makes sense that the addressees are governments, the people who promulgate the laws, who develop the laws. But if human rights are also moral rights, and so, for instance, 200 years ago, everyone had a moral right to life, even if the law did not recognize that, then if human rights are moral rights, it's easier to make the case that human rights are also held against every human being. So if, for instance, I was walking along in the forest and someone else met me 200 years ago, someone else met me in the forest and decided to kill me, we might say, on this understanding, that he violated my human right. It's a right, it's my right to life. It's a right I have as a human being, and it's a right that every human being has just by virtue of being a human being. Even though the government isn't involved in this case, we could plausibly say, on this understanding at least, that this person, this murderer, violated my right to life. If instead you think that only governments are the addressees of human rights, then what this person did was not violate my human right, but some other right. Namely that we needn't deny that there is human rights law, and there is an international human rights law, and there are also domestic human rights laws. But that doesn't answer the question of whether or not there are also moral human rights that have not yet been enacted by the law, or that have been enacted but that nevertheless remain as ratified within the correct moral system. Now you might doubt that, because you might say there is no uniquely correct moral system, and that morals differ from society to society. Human rights are meant to be universal, and so there cannot be any universal moral rights, only universal legal rights, provided they are recognized by every society's laws, or at least an international body of laws. But I think that nothing you've said, Farhad, shows that there are not, in addition to legal human rights, moral human rights. And I think what we need to do is, when we get into debates about which human rights there are, we need to be clear about whether we're talking about a legal framework or a moral framework. If you're talking about a legal framework, the answer to that question is fairly straightforward. You go and take a look at the statutes and documents of the relevant human rights law to discover what human rights there are. The answer to the question, if you're posing it as a moral question, namely what moral human rights do we have, is not so easy to answer. And this is not a seminar in legal practice, and so I'm not going to just tell you I don't need to tell you what the UN Declaration says and which rights it identifies. We're here to ask whether there is a moral foundation for human rights. Okay, let me talk about another distinction that I need to make two more distinctions, and then we'll be largely done with distinctions. Then I want to ask a more substantive question. The next distinction is a very popular distinction within the rights literature, and that's the distinction between negative and positive rights. And the problem with this distinction is that the distinction has been made many different ways. So here are the two basic ways of distinguishing between negative and positive rights. And we will talk about the implications of these distinctions tomorrow. So first of all, here's one way to distinguish between negative and positive rights. This is what I will call the factual distinction between negative and positive rights. A negative right is a right that requires only inaction on the part of others. And a positive right is a right that requires action on the part of other people. So a negative right is one that requires only inaction from others. And a positive right is one that requires action. It requires that other people act in some way. Now the problem with, before I go on to mention the second distinction, I think that this notion of negative and positive rights, this is a technical notion. This is a term of art. This is not a notion, if we left this room and talked to the person down the streets, if they spoke English and you said, negative and positive rights, what do you think the difference is? They'd say, what are you talking about? I have no idea. Right? So this is a term that philosophers invented. The thing is that philosophers and legal theorists have ended up using these terms to mark two different distinctions. But we have paradigm cases of positive and negative rights, and these have helped to make the distinctions that we need to make. So a paradigm of a negative right is a right to life, for instance, a right not to be killed. A paradigm of a positive right is a welfare right, a right to have some kind of assistance given to you, a right of a minimal level of health care, for instance, or a minimal level of economic well-being, which requires the activity of a government, typically, in order to provide you with that right. But the problem is that this factual understanding does not completely do justice to some of the paradigm cases that we have. For instance, a right to life is a classic a classic example of a negative right. But what if I'm drowning and all you need to do to save me is to throw me a rope that's right here in front of you? If you don't throw me that rope, then most people will think you violated my right to life. You could have very easily saved me, and you didn't. Right? So you violated my right to life. But in this case, if I have a right to life, that calls on you to act in a certain way. Pick up that rope and throw it to me. So here we have a paradigm example of a negative right, and yet it requires action on someone's part. So there's this kind of example has led people to consider a different understanding of the difference between negative and positive rights. And I know that Kit Wellman's going to talk a lot. He's actually going to devote a whole lecture to this, so I'm just giving you the very basics of it. The alternative understanding is what I call a normative understanding of this distinction. And according to this normative understanding, a negative right is a right that is correlated with a duty not to impose harm. A duty not to impose harm. Whereas a positive right imposes a duty to offer aid or assistance or help. The distinction between negative and positive rights, as you can tell from this characterization...
Could you repeat again the second?
Yes, I'm sorry. According to the normative understanding, a negative right is correlated with a duty not to harm, and a positive right is correlated with a duty to help or to provide aid or assistance. And as you can tell from this characterization of the negative-positive distinction, these are all claim rights that we're talking about because they're all understood in terms of the duties of other people. Okay. So I think that the normative understanding is one that for the most part is endorsed, but when you go on and do your own reading in the human rights literature, you will often see this distinction made, and I think it's common for authors to to be ambiguous, to use these two different meanings without realizing that they are actually referring to two different distinctions between negative and positive rights. Farhad?
I'm sorry, I don't want to ask so many questions, but I want to clarify something. The negative and positive rights is not the same as the negative and positive obligations of the state. But I think if you give us some clarification, it will be for the benefit of the society here. I mean, there is some negative rights which impose positive obligation on the state. For instance, right to life. It's usually it's a negative right. But if I claim for the protection from the state, for instance, on the discriminator basis, if I got, for instance, a letter that I'm going to kill you because you are black, and I apply to the police that I need in protection because someone is going to kill me, there is a positive obligation for the state to protect me. I mean, maybe it's a police officer who is going to protect me.
So that's a very good point. And there's disagreement within the literature about how to understand this. So there's a guy, Henry Shue, who teaches at Oxford, who's written a very important book about human rights. And what Shue thinks is that every human right actually is a combination of negative and positive rights. Because he thinks, for instance, of this paradigm right, a right to life, that this imposes actually a duty on all other human beings to refrain from harming me, but also it imposes a duty on the government to come to my aid to prevent me from being harmed, or if I am harmed, then to come to my aid and provide a remedy for the harm to the extent that that's possible. I know that Kit is actually going to talk a lot about this, so what I'd like to do is not talk any more about this and let him discuss the benefits of taking that approach as opposed to the more classic approach, which understands negative rights solely in terms of a duty either not to do anything at all or not to harm. Okay, the last distinction I want to make before I talk about something... Oh, look at that. I'm not even going to make that distinction. I want to talk instead about, since I only have 10 minutes left, to ask a question about the grounding of human rights. And I want to do it in terms of an answer that most of the groups gave, or a version of this answer that most groups gave about what grounds human rights. And the answer is dignity. And here's a problem with that answer. The problem is that, what does dignity mean? Dignity is a very, very vague term, and it imposes no criteria for determining what counts as rights respecting behavior or rights violating behavior. So when I teach an introductory ethics class, for instance, I often teach about the case of capital punishment. In the United States, we still have capital punishment, the death penalty. If you commit murder and a few other crimes, you can be executed for your crime. A lot of people in the United States think that's a terrific idea. Most people do, and some people do not. Okay. I always teach the moral philosophy of Immanuel Kant in my introductory ethics class. And I tell people that Kant thought that what is most important in our dealings with one another is that we treat one another with respect for the dignity that each human being possesses. And then I tell them that Kant thought that the death penalty is morally acceptable. In fact, it's morally required. Kant thought that if you, the last thing, has anyone read the Metaphysics of Morals? I don't know what the Russian translation is, but not the groundwork, but the actual metaphysics of morals, where what Kant says is that if a society is about to break up, the last thing it must do is to execute the murderers among them. No mercy. And my students always ask me this: if Kant thought that human dignity is so important, how can he think it's acceptable to kill people? That's a very good question. I'm not going to try to answer that question. Instead, I use that example to point to this problem, namely the problem that dignity, the notion of human dignity, is so vague. It's so indeterminate that we cannot rely on it to provide a grounding for human rights. Because any debate about human rights will not be resolved by making reference to human dignity. If someone is not, in the UN Declaration of Human Rights, there is a right to paid holidays, paid vacations. Now, do we have a human right to paid vacations? Some people might, those people who say yes, say it's required to respect human dignity. Human beings require vacations. If they don't have paid vacations, they are not living a dignified life. Other people say, no, we can have human dignity even if we don't have vacations, or even if we have to pay for vacations ourselves. Now, probably one side is right and the other is wrong, but making reference to human dignity is not going to solve that question. I'm sorry, Farhad, I just want to speak for another 5 minutes, and then we'll take our break, and then we can continue over lunch. So that's a negative claim on my part, namely that human dignity is not going to be adequate to serve as the ground, as the basis of human rights, because that idea, namely the idea of human dignity, is so indeterminate, it's so vague. But if that's true, then what else is going to serve as the basis? If we think about Kant for a second, Kant had a basis of dignity. He did not rest his analysis on dignity. He said there is something that in turn provides a basis or a grounding of human dignity. It's two things: rationality and autonomy. We are dignified, we possess dignity because we are rational and we are autonomous. We can use our reasoning in very complex ways. We are rational. We are self-legislators. We can determine the law that we will live by for ourselves. We are autonomous. And these two features are what explains why we have human rights, according to Kant. Because we have human dignity, but that's because we have rationality and autonomy. And these ideas are somewhat vague, but actually much more determinate than the idea of dignity. And we can use these as a test for determining whether people qualify for human rights. Because after all, here's an interesting challenge. In one sense, we say human rights are those rights had by all human beings in virtue of their humanity. Okay. Well, they're had by all human beings. Does that mean that a baby who is 1 day old has human rights? Yes, of course. Maybe not?
No.
No. Okay, good. We've got a disagreement. So let me just tell you about this, this book that I was just reading, this book by James Griffin, for instance, called On Human Rights. The latest big book on human rights in English, at least by a philosopher. And what Griffin says is, newborn babies, they don't have human rights. People who are severely mentally retarded, they don't have human rights. People who are in a coma, what's the Russian word for coma? Okay. People who are in a coma,